Is there another case that was supposed to? Oh, I'm sorry. Thank you. All right. And also LM Insurance Corporation versus Rick Price and WMP Restoration Services. All right. So Mr. Williams is here on behalf of Chef Mike's Jamaican Bar and Grill and himself. Is that correct? Mr. Williams?
Yes, Your Honor, I'm here, Your Honor.
All right. So Mr. Williams, I have to see you for the hearing.
Okay, Your Honor.
All right. And Mr. Foss Baker is here, attorney for Best Plaza LLC.
Yes, Your Honor.
All right. So it's my understanding that this is a de novo appeal to a writ of possession that was issued by the magistrate court. Is that correct?
That's my understanding, Your Honor. Mr. Williams has yet to serve a copy of the appeal on us, so I've yet to see it. But yet my understanding is appealing both the money judgment portion and the writ of possession that was granted by the magistrate court.
Okay. All right, Mr. Williams.
Yes, Judge.
What's the basis of your appeal, sir?
Judge, is this I would like to get this on record, Judge. It
is on record, sir. It's being recorded and it's on live streaming through YouTube. Both are means by which you can get copies later if you need to.
Okay, Judge, thank you.
So what is the basis of your appeal, Mr. Williams?
The basis of my appeal, Your Honor, they are trying to evict me from this property wrongfully.
Okay. And why do you believe that the eviction is incorrect?
Because the purpose is pertaining to a sign.
Okay. All right, Mr. Foss, since it's your company that's seeking the eviction, can you tell me what's going on?
Yes, Your Honor. Mr. Williams was right to a certain extent. The dispossessory was filed as a result of Mr. Williams and his company improperly installing a sign at the premises, which is a prohibited activity by the lease. The lease requires that the tenant obtain written permission from the landlord before installing any sign, whether at the marquee on the road or the sign above the actual premises. Mr. Williams didn't do that. Nobody from his company did. And it actually caused physical damage to both the marquee and the overhead sign that, to our understanding has yet to be repaired. I believe, Mr. Williams did submit some exhibits this morning showing that there are new signs in place, but, as a way of procedure, Mr. Williams didn't get permission for those signs either. So, that's just, if we want to take it as either a continuing default or a new default, it's certainly still a default.
As a practical matter, with commercial space being somewhat hard to find tenants for in this day and age, it seems that there would have been opportunity to cure unless there's some kind of issue with the communications between the two entities. Seems that there's maybe not the best relationship between the landlord and the tenant.
Well, Your Honor, I think both tenants would certainly stipulate to that. There's been, police reports filed by one against the other, a few times. Other tenants in the shopping center have also filed, police reports based on noise violations here. And as, a further procedural matter, we believe that this appeal is untimely because of Mr. Williams' failure to pay, both timely rental payments into the amount, and then the magistrate court also awarded $2,625 of attorney's fees that were to be paid into the registry upon filing an appeal. That has not been done. So, in addition to the violation of the Eccles rule in Georgia, we take the position that this appeal fails for multiple reasons.
Okay,
Your Honor, Your Honor,
Yes, yes,
Your
Mr.
Honor.
Williams.
My lease is with the corporation, Your Honor, not with Chef Mike, not with me, and they're suing me.
So, Mr. Williams,
Yes,
here's
ma'am.
the issue too, that there seems to be some confusion about the nature of the entity that was operated at that location. So if it is a corporation, then it has to be represented by an attorney in state court. And then you can represent yourself, that's fine. But you've indicated now, to my understanding, that you operated as a sole proprietorship and it doesn't require an attorney. But if you are operating it as a sole proprietorship, then they can sue both you and the entity.
Yeah, but I'm LLC, but what they're suing is, I'm a business LLC. What they're
Well, if
suing,
you're an LLC, as we pointed out to you before, you need an attorney to represent the
Yes,
corporation.
Your Honor, but they didn't sue the LLC, Your Honor. They sued Chef Mike Jamaica Bar and Grill. They did not sue the LLC.
Whose name is the lease in?
Mine, Chef Mike Jamaica Bar and Grill LLC.
Mr. Baker, I'm sorry.
Yes, sure. That's okay. Yeah, so, the lease actually stipulates that Chef Mike's Jamaican Bar and Grill is a trade name, indicating the presence of the LLC. I mean, at this point in time, we have no issue dropping him individually from this matter and, just seeking the money judgment and writ of possession against Chef Mike's Jamaican Bar and Grill LLC and all other occupants. My firm got involved in this after the initial filing, so certainly not excusing any procedural error that Best Plaza's previous attorney might have made, but according to the Georgia Secretary of State, this is an LLC, and as such, he's not able to testify on behalf of Chef Mike's Bar and Grill.
So, Mr. Williams, I can accept testimony on your behalf, but here's the way that dispossessory works in Georgia.
Yes, ma'am.
The landlord could have listed Chef Mike's Bar and Grill, whatever the whole name is that's indicated on the lease, and all other occupants, which would have included you or anyone you subleased to or anyone who was in the property at the time of filing. So it is not particularly necessary that they name you individually. And Mr. Baker is indicating that they're really not seeking redress from you as an individual. It's really that they want the business to pay for the attorney's fees for the judgment that was granted below, which the court will go over that. And then also to have possession of the property because of the breach with the signs.
Your Honor.
Yes, sir.
We request a jury duty, a jury trial, Your Honor, and that was not granted.
We don't do jury trials on dispossessories, Mr. Williams.
And Your Honor, I would just
This one-
reiterate
this one-
any request filed on behalf of Chef Mike's Jamaican Bar and Grill LLC would have been invalid anyway per the Eccles ruling.
So, yeah, once again, Mr. Williams, the entity that is in the property is an LLC.
Yes, ma'am.
An LLC needs an attorney to represent it in state court. You don't have an attorney to represent that entity. You can't speak on behalf of Chef Mike's. You can only speak on behalf of Michael Williams. Sir, I can't have you on the phone while we're on the hearing. Now, if you wanted to hire an attorney to be here with you, that's fine, but I can't have you getting advice from someone on the phone while we're on the hearing if they're not a part of this hearing. That's not gonna work for me.
So in other words, then we're gonna set another date for this hearing to get.
No, sir. No, we're not, because in the notice for trial or today, my staff attorney was told to indicate to you that the entity needed an attorney to appear on its behalf, and that did not happen. So in that case, I can issue a default judgment with respect to the landlord's claims against Chef Mike's Bar and Grill. And they're willing to drop claims against you. So that would end this process right now. All I would have to do is have them to testify as to the damages and any amounts of rent owing and due at this time. Mr. Williams, let me explain something to you. And I hate to give this speech, but I spent 4 years in magistrate court giving this speech. When you operate a business, you have to operate a business in a business-like manner. You can't try and cut corners. Well, I'm operating a business, but I don't want an attorney because I'm going to try and figure out how to do it on the cheap. You can't do that. If you're operating a business and your lease says one thing, you can't do the opposite and not expect there to be consequences. If your lease says, I need to contact the landlord to determine whether I can put up a sign, then if you don't do it that way, you're wasting money. You're wasting money on the sign. You're wasting money on the consequences to your business because of the breach of the contract. And you're not operating in a business-like manner. It drives me nuts for small businesses to think that they can do everything when it comes to operating a business. My indication is you're operating a Jamaican restaurant. You probably cook really well, or whoever works for you cooks really well, but you don't know the law. But to try and figure it out on the go without hiring a lawyer to assist you, sometimes that is a necessary business expense. And what a lot of small businesses do is they skip over those necessary business expenses because they think through delay or through confusion that they'll be able to maintain their position either in the property or whatever they're seeking to have. And that's not going to work with me. I've done this too long. I've seen too many businesses who don't operate in a business-like manner, but expect to win in a hearing. You see what I'm saying?
Your Honor, I get the permission for the sign. I get the permit for the sign. And
No, sir. You've already passed that point. We're already at the second hearing about this. Magistrate court has already granted them relief, and now you're here for a de novo hearing. If they are able to show me that you didn't get permission for the sign, I'm going to have to grant the same relief. But what I'm stating to you is I'm only talking to you as Michael Williams. There's already a default that's going to be granted against Chef Michaels because you don't have an attorney representing you.
But I'm here on what I'm saying here on I'm operating at the LLC. They sue Chef Mike
LLC.
Michael Williams.
LLC. That's all I need. You need an attorney. Ms. Fortson, did you send him the information that he needed an attorney on behalf of the entity?
Yes, Your Honor, it was noted that Chef Michaels did require legal counsel for this hearing.
So you were given notice and an opportunity to get legal counsel prior to this hearing, Mr. Williams. I don't often do that. I had her alter my notice, the one I usually send out, to make sure you are aware that to operate in state court, the business was going to need an attorney. All right, so Mr. Baker, you've alleged breach of the lease based on the sign. Are there damages that come with that?
There are, Your Honor. Right now, the main redress we're seeking is attorney's fees, which are contemplated under the lease. We don't at this time have an amount of damages as to repair the sign because we, without interfering with Mr. Williams or Chef Mike's possessory interests, we can't really figure out all the damages right now. So that, might just need to be a subsequent action.
Okay. So let me understand. So in the lease that was between the LM Insurance Corp, I'm sorry, I'm looking at the wrong one, between Best Plaza LLC and Chef Mike's Jamaican Bar and Grill LLC, the requirement was to first get a written permission to alter or to erect a sign.
That is correct, Your Honor.
All right. And on what day was the sign, was it first noted that the sign had changed and there was not permission granted?
So we don't know the exact date of installation of the sign. We do know that it was in the summer of 2021. As a result, my client sent Chef Mike Jamaican Bar and Grill a notice on July 29th stating that, if you wish to use the sign, please provide us with sign details and expected date of completion. If you don't want to use the sign, we can assign it to another tenant. Chef Mike didn't do anything. Nobody from the corporation did anything. They left the sign that were damaging to the property.
Object, Your Honor.
Mr. Williams, hold on, sir. What are you objecting to?
They don't got the right time and schedule, Your Honor.
Okay, well then, when it's your turn, you can tell me what the right time and schedule is, sir.
Okay.
All right, go ahead, Mr. Baker.
And then, as a result, on August 23rd, my client sent another letter, specifically laying out that, I've already notified you of the default, you didn't get permission. And now, putting him on notice that there's damage to the signs, again, asking him for any particulars of the signs. Nothing was provided, requested that they remove and repair any damage immediately. That wasn't done. And then again, I think I mentioned this, but submitted another request, for Chef Mike to submit his plans to the landlord. None of that was done. And the way that they were installed, Your Honor, is, I'm sure you're familiar with like the roadside marquee signs, that have the lenses.
Yes, where there are several entities can be represented in one sign.
Absolutely, Your Honor. The way that the sign company installed these at the request of Mr. Williams or someone from his company was that they were just bolted into the lenses. They weren't affixed to the lenses in an appropriate manner. And now the lenses on both the marquee sign and the overhead sign have to be replaced. They're a type of like hard plastic or vinyl material that's been screwed into, which has caused cracking, and there's no real way to repair that without replacing. And then, in addition to that, Your Honor, it appears that Mr. Williams submitted a permit request to the city of Marietta and signed it as the owner of the building, or at least an authorized agent of the building.
Okay, two things. One, what section of the lease is this covered in? And two, what date was this permit request sent to City of Marietta?
So the lease is section 5.2 subsection E, which forbids I'll just read it exactly. It says, install no signs in or upon the demised premises or on the shopping center property without the prior written consent of landlord. Pretty clear that, it requires both a written request for permission and then written actual permission from the landlord. And then the application to the city of Forest Park was submitted March 25th of 2021, or at least that's when it was signed. A corresponding permit was issued on March 26th, 2021. And it says Mike Williams under signature of owner or contractor or authorized agent. Mr. Williams was none of those things, and had no authority to act on behalf of Best Plaza in any way, and certainly not in this way.
All right.
And so, as a result, the two demand letters previously mentioned were sent. Mr. Williams took no corrective action, a point that, the magistrate court was very keen on pointing out. I know this is the de novo appeal and y'all don't owe any deference to the magistrate.
But we do wish to know if there's been an opportunity to cure. And in this case, you've indicated that there wasn't at least two opportunities or notices to cure before eviction was taken.
Yes, Your Honor. And so this dispossessory was filed back in October of 2021. Amended dispossessory was filed June 21st of 2022. It came before the trial court the magistrate court on June 23rd. And Judge Parker of the magistrate court issued a ruling saying that a writ of possession was appropriate, that Mr. Williams had been properly notified and given an appropriate cure period. He took no corrective action, and then required that in the event of an appeal, $2,000 per month to be paid into this court's registry starting July 1st. And then upon filing of the appeal, $2,625 would be paid to compensate Best Plaza for its attorney's fees incurred in pursuing this unnecessarily. And I will be honest that Mr. Williams has made the payments eventually. His payment for July was 13 days late. His payment for August was 29 days late. His payment for October was 2 days late. September, November, December appear to have been paid on time to this court's registry. I would, point out for the record that December's payment, the check was addressed to Fulton County, not Clayton County. So there very well could be an issue on whether or not Clayton County even has authority to deposit that check. And, the other kind of issue here is that, even if payments are eventually made, a late payment itself is cause for writ of possession, even if it's 2 days late, Your Honor. And we have case law to support that. I'd just like to bring the court's attention to Diplomat Restaurant versus Anthony. The citation for that is 180 Georgia App 431, where a writ of possession was granted when a payment was merely 2 days late. Here we have several payments that are multiple weeks late, some even a month late at most. So, for the grounds of failure to obtain an attorney and an appeal that, the defendant is now prosecuting unlawfully as per Eccles, and then failure to timely pay his rental payments, and then also failure in any way to pay the $2,625 as ordered by the magistrate court, we believe that this appeal should be dismissed, costs should be awarded against Chef Mike's Jamaican Bar and Grill, and a writ of possession should issue in stanza.
All right, Mr. Williams.
Yes, Your Honor.
Tell me what's going on, sir.
Your Honor, I lease this property. First of all, they're suing, they didn't put the LM Chef Mike LLC on this claim. They're suing Chef Mike Jamaica Bar and Grill. They're suing me personally, not my LLC. And I think that is wrongfully sued against me to say, and not my LLC. And I think this case will be dismissed because of fraudulent charges.
You didn't install a sign at the location?
Yes, sir, and I installed the sign with the Ray permission, Your Honor. He told me verbally.
With
Ray,
whose
that's his
permission?
name. Ray Hassani, he told me verbally to install the sign.
Okay, did you get that in writing per the lease?
And also, Your Honor, objection to hearsay. Mr. Hosseini hasn't been called to testify.
I got you. Did you get that in writing per the lease?
No, I didn't get it in, but I have it on a videotape, Your Honor.
Okay, but you understand that the lease requires that it be in writing and that you provide certain other information regarding the sign.
So I provide information regarding to the sign because I went and I get the proper to fix the problem, and there still is a big issue. They just want to get me out of the property.
Okay, I get that, Mr. Williams, but if you give them reason to get you out of the property, if you know there's not good relations, then you toe the line and you do everything per the lease. When you start calling an audible or doing things on your own, then you give them the way to get you out of the property. If you don't have good relationship with your landlord, then the four corners of the lease, you need to do everything that says.
Okay.
You need to hold them to their responsibilities, and they will hold you to your responsibilities per the letter of the lease. But if you already know that there are issues between you and the landlord, then it doesn't make sense to deviate from the written word, because when a judge looks at the relationship between you and the landlord, I can't take that you had an agreement on the side.
Well, I don't have a problem with him, Your Honor.
Hold on. Verbally, what I am bound by is the four corners of the lease. And if the lease says that you got to get a written agreement, unless you alter the lease to say a verbal agreement will be acceptable, and that's in writing, then I have to go by what's in writing on the lease. Okay. Did you want to call Mr. Hassani and ask him as a witness whether y'all had an agreement?
You're talking to me?
Yes.
Yeah, he's not going to say we have an agreement, because he's going to tell a lie. It's discriminating. It's discrimination against me. He didn't know that my business was going to be successful, and because I'm black, and they
I
want.
mean, objection.
Williams, that's
certainly,
not
Your
gonna
Honor.
fly. No, sir, that's not gonna fly. Because, and I tell you why. Folk don't, when it comes to business, especially getting people into plazas and strip malls, because we got a lot of them that are empty. What they're looking for is money and a good tenant. So the fact that you think that this was about whether you were black or white, I think less so, because you didn't follow the lease, sir. So
Your Honor,
that's the gravamen of this issue.
Your Honor, you're saying a plaza is empty, but I never laid them a rent, Your Honor.
No, I'm saying that there are a lot of plazas and strip malls that are empty, that have lost tenants. So if you are a good tenant who is paying, then they're not going to mess with you on that. But if there have been issues in your tenancy, then yeah, they may want to get you out. Probably has very little to do with your skin color, but more to do with how your business is run, or whether there have been issues between the landlord and the tenant. That's what I see most. Now, here's what I have. I have that they've indicated that you did not follow the lease. That was the breach. You received a letter on July 29th asking you to, giving you notice that there was a breach and giving you the opportunity to cure that breach. You then received another letter on August 23rd asking you to cure the breach and giving you notice, giving you notice of the breach and asking you to cure it. And each opportunity that they gave you to make it right, you didn't take that opportunity. Am I wrong? I mean, because I'm
Your
going
Honor, I did take up the opportunity, Your Honor, but he said, he went back and told me, I know it's hard time. You don't have to worry about it right now. They're liars, Your Honor. They're liars.
Objection is to hearsay.
All right. Well, Mr. Williams, even if that were the case, knowing that your lease is in writing, if there's any, what we call a novation of the lease, meaning any changes or making a new lease, you got to get that in writing. Your lease is in writing. You signed on to a written document. So if there are going to be any changes to that document, you want to get that in writing.
But Your Honor, we're drifting from the whole point, though, Your Honor.
What's the whole point, Mr. White?
My business is Chef Mike Jamaica Bar and Grill LLC.
Mm-hmm.
What they want to do, get Chef Mike LLC out, or they want to get Michael Williams out?
Well, let me just say this. They've already said that they don't really care about you being in this litigation. So they could drop you, and they just want Chef Mike's Bar and Grill LLC out of the business.
Okay, so they need to go drop this case and go back and file against the Chef Mike Jamaica Bar and Grill LLC.
No, sir, they can just dismiss you.
They dismiss me and then go file a charge against Chef Mike Jamaica Bar and Grill LLC. Am I right, Your Honor?
Mr. Foss, he's indicating that you didn't sue the proper entity.
Yeah, so, Your Honor.
Mr. Baker, I'm sorry.
It's okay. Your Honor, our position is, trade names are appropriate to sue under, especially in dispossessory actions. The business name on the sign, ironically, that is at issue is Chef Mike Jamaican Bar and Grill. That is an appropriate party to this lawsuit. This was not, also, we would argue that any defense to that is waived. This was not brought up in magistrate court when Chef Mike Jamaican Bar and Grill did have an attorney. It wasn't raised in the answer. It hasn't been, brought up. So, really, we'd argue that that's, barred through a res judicata argument. And they answered, Your Honor.
So, Mr. Williams,
Yes, Your Honor.
The entity, as I've stated earlier, you can't represent the interest of the entity, because if you're saying that it's an LLC, then you need an attorney to make that argument.
Okay, then, Your Honor, I will get an attorney.
No, sir, because I gave you notice that an attorney was required today.
Because they sued the entity, personally.
No, Mr. Williams, I gave you notice that an attorney was required today.
But here, an attorney is not required when you're suing a person, a sole proprietor.
But, I mean, Your Honor, his testimony is borderline perjury here. I mean, you know, it's registered by the Secretary of State. This is not a sole proprietor. He's admitted that this is an LLC. Several times he has admitted that this is an LLC.
Yeah, it is a LLC, but you sue sole proprietor. You sue the sole proprietor. So if you want to go ahead and go to sue the LLC, go ahead and sue the LLC, not sole proprietor. That's all I'm saying here, Anna.
So, Mr. Williams, did you have anything else at this time that you needed me to know?
Yes, Your Honor. I would like to put this, make this be on record and make sure that they go ahead and file it, sue the LLC, not sole proprietor, not me. My restaurant is Chef Mike Jamaica Bar and Grill LLC.
Okay.
Chef Mike Jamaica Bar and Grill LLC. I'm Michael Williams. I'm the proprietor.
I got that,
And
Mr.
they're suing the proprietor, not the LLC.
Actually, they're suing both, but they're you in there as an individual who operates the business, but they could have covered you with all other occupants. I mean, they didn't have to name you separately. And they said earlier in this hearing that they really don't need you as a part of this. What they're wanting is possession of the property from the LLC.
Okay, so did they go ahead and sue the LLC?
Well, if there was an attorney here to represent that, then maybe I would take that argument.
But Your Honor, they want to get all the LLC from the property, not me, proprietor. Is the LLC, Your Honor.
And Your Honor, just as a
Williams, we're going around in circles. Yes, Mr. Baker.
just as a, you know, at the trial in magistrate court, you know, his attorney appeared on behalf of the LLC and argued on behalf of the LLC. Your Honor knows that once you file an answer, you subjected yourself to venue and jurisdiction of the court, whether that be as an individual or as an LLC.
Object, Your Honor.
What are you objecting to, Mr. Williams?
What he's saying, my attorney, that attorney, I had us to fire him because I told him he
Okay, sir, I don't want to know what you told him. That's attorney-client privilege, and I don't want you to waive that here before this court. But you were given the opportunity to get another attorney. So I think I've heard all I need to hear, except for one thing. So Mr. Baker, you're alleging that attorney's fees below were $2,625, and that the rent for $2,000 a month was paid into the registry. What are the current attorney's fees that you all are seeking?
Yes, Your Honor. So right now, including today's preparation and attendance, our fees are a total of $5,249. That represents 20.2 hours of my firm's work. I've done most of the actually, I believe I've done all of the attorney work on this matter. I'm a licensed attorney in the state of Georgia. I've been practicing for 6 years. My rate at the beginning of this matter was $275 an hour. It's increased just recently to $295 an hour. You know, that's a reasonable and appropriate fee for an Atlanta area attorney with my level of experience. I supervise a paralegal whose rate is $195 an hour, and an office manager and administrator whose rate is $125 an hour. You know, all those fees are reasonable and appropriate given the circumstances and expertise in this area of the law. Okay. Oh, and my main practice areas are commercial real estate and civil litigation.
Okay. All right. So at this time, the court finds that Chef Mike's Jamaican Bar and Grill is in default because it's not represented by an attorney. Mr. Williams, the proprietor and owner of the entity, was given notice prior to this hearing that an attorney would be required to give argument and to represent the entity known as Chef Mike's Jamaican Bar and Grill. Mr. Williams has indicated that he has not brought an attorney on behalf of the entity. And so the court will find that default will issue and a writ of possession will issue in stanter. Further, below, the court ordered that $2,000 per month be paid into the registry of the court because the bar and grill continued to occupy the commercial space. That $2,000 per month will be turned over to the Best Plaza LLC. So the clerk of court shall be ordered to forward the total amount paid to date to the entity known as Best Plaza LLC. And the court will order that $5,249 in attorney's fees be paid by Chef Mike's Jamaican Bar and Grill LLC.
But Your Honor, I'm saying they didn't sue Chef Mike Jamaica Bar and Grill LLC, Your Honor. So why all this?
Mr. Williams,
Again, Chef Mike.
Mr. Williams, I'm not playing this game with you, sir. I've already made my ruling. So all the writ of possession shall issue against all other, Mr. Williams and all other occupants. The judgment for money and fees shall be against Chef Mike's Jamaican Bar and Grill. All right.
Your Honor, would the court like me to present an order or will they draft it?
Yes, that would be fine.
Okay.
Just
And I
make
can-
it
I would
specific.
like to make an request, Your Honor, for an appeal.
No, sir.
I
You,
would like to,
Mr. Williams, Mr. Williams,
yes,
Mr. Williams.
yes.
What I need you to do, sir, is if you're gonna run a business, run it in a business-like manner. You can't just make decisions that run contrary to the agreement that you made with your landlord. You can't just decide that you're not gonna operate in a way that is going to be what you agreed to operate under.
So, Your Honor,
And when the court gives you notice that something is required, I've given you a heads up that I didn't have to give you. You ignored it and decided that you knew better. So with that being said, I've made my decision, Mr. Williams. Now you do what you need to do, but the writ of possession has issued and it will issue instanter. So you may want to be focused on making provisions to move your business to another place. All right. Anything else, Mr. Baker?
I don't have anything else for the court, Your Honor.
All right. All right, Mr. Williams, Mr. Baker, you all excused at this time.
All right. Thank you, Your Honor. Have a great day.
You too. All right, the next case is
yes,
LM Insurance Corporation, Attorney Richard Howe versus Rick Price, DBA WMP Restoration Services. Are those entities here?
Good morning, Your Honor. Zach Proctor on behalf of Mr. Howe.
Okay,
And Your Honor, we were requesting an additional 30 days. We've not been able to serve defendant in this matter.
how many times have we continued this for service, Mr. Proctor?
I'm sorry, Judge.
How many times have we continued this for service?
I am unaware, Your Honor. I apologize. I'm appearance counsel and was not provided that information.
All right, the court will grant one further continuance for service, and this will be the last one, okay?
That is perfect. Thank you, Your Honor.
All right, thank you, sir.
Good to see you, Judge.
Thank you. Good to see you too.
Merry Christmas.
Bye-bye, you too. All right.